Dear participants, thank you for joining in. Today's session promises to be highly interesting because Professor Dr. Henscher is willing to share some of her thoughts on state aid and industrial policy in the context of sustainable recovery with us this evening. A subject that could not be more topical. We've been allocated roughly 90 minutes, and this includes time for discussion. And to make sure we make the most of our precious time, I suggest to proceed as follows. Firstly, I will briefly introduce today's topic. That will take between 5 and 10 minutes. Subsequently, Professor Henscher will discuss 5 topics that I will present to her one by one. And on each topic, she intends to speak around roughly 10 minutes. And after each topic, we'll have around 5 minutes for general discussion. If you would like to ask a question or share an observation, please indicate so in the chat. And then subsequently, I will give you the floor and you can unmute to ask your question. And that way, we'll keep the discussion orderly. Then to the topic of today. The relationship between industrial policy and the various branches of competition law and policy, including, of course, the prohibition of state aid, has been the subject of continuous debate. And relevant questions in the respect are, does the EU enforcement of competition law endanger the competitiveness of EU business on a global scale? And of course, conversely, can competition policy support various types of industrial policy objectives? And if so, to what extent should such considerations feature in enforcement? As you might know, since 2010, a considerable number of industrial policy papers have been published by the Commission, the most recent one earlier this month. And what we can observe is that while initially a rather market-oriented, cautious approach was advocated in the European public interest, nowadays there's a renewed interest at the EU level on the need to become more strategically autonomous. That's a new buzzword in the current global economic environment. By diversifying supply chains and making sure there are critical capabilities domestically or at least within the European Union. And the COVID-19 crisis has reinforced this trend and further added medical nationalism, vaccine nationalism, and more generally, a strengthening of the role of the state in domestic economies. And this has been facilitated further by the adoption by the Commission of the temporary framework for state aid measures. And this partially changed paradigm has had real effects already. Consider, for example, the EU's foreign investment screening mechanism, the Commission's very recent proposal for regulation on foreign subsidies, and the proposal for a Digital Market Act. And interesting for today's session is that this development is linked to the discussion whether competition policy should also service other strategic objectives, such as sustainability goals. In its current industrial policy strategy called a New Industrial Strategy for Europe, the Commission has merged its goal of reinforcing Europe's industrial competitiveness with its overarching objective of a transition to a green and digital economy. And this is also visible in the Commission's most recent update earlier this month. And last year, and I'm sure you're familiar with this, the Commission launched a call for contributions on how competition rules and sustainability policies can work together. And in particular, how antitrust policy in a wider sense, including state aid, can further support the objectives of the European Green Deal. Today, we will focus specifically on state aid. And as you know, state aid is arguably one of the most important domains where the EU level has extensive powers to conduct industrial policy. The central objective of EU state aid regime is well known. But also, EU state aid law control aims to strike a very careful balance between, on the one hand, European unity, and on the other hand, national sovereignty. And this entails that while decisions to provide aid are in principle made by the member states, the EU legal framework generally generates systematic obstacles that can preclude or limit the adoption and application of national industrial policy measures that entail monetary support. Of course, in the context of COVID-19, this balance has arguably temporarily changed. The Commission's temporary framework grants member states an unprecedented degree of flexibility. But I think in general, we can say that by inviting member states to provide so-called good aid as opposed to bad aid, the EU has increasingly aimed to impact on the economic policy of its member states by making use of its discretionary powers under the third paragraph of Article 107, while preserving competitive structures in the market. And combined with a whole range of supranational funding possibilities, such as, just to name a few, the European Green Deal investment plan, including the Just Transition Mechanism, the Regional Development Funds, the Social Fund, the Cohesion Fund, EU's Next Generation, 750 billion recovery instrument. This enables the Commission to use state aid as a public governance instrument to advance positive European industrial policy in the absence of full harmonization. And although this is arguably in line with how Article 173 of the TFEU on industry could be interpreted, the Commission's use of its discretionary powers under Article 107, paragraph 3 raises some questions as to the distribution of national acceptance of systemic intervention. And this arguably also applies to the Commission's proposal for regulation on foreign subsidies. Well, that was a short introduction on state aid and industrial policy. And now we have arrived at the 5 topics to be discussed by Professor Hanschen. The first topic to be discussed is the temporary framework and sustainability. The temporary framework, which is based on Article 107.3b of the TFEU, recognizes that the entire EU economy is experiencing a serious disturbance and explicitly allows member states to take certain action. However, one of the main criticisms has been that the Commission has not explicitly included environmental conditionality in the framework. This means it is largely up to the member states to attach green conditions to state aid schemes operating at the national level. And my question to Professor Hanschen is, to what extent was and is there a need to adopt a more forward-looking state aid framework that can a green economic recovery from the COVID-19 crisis? Think, for example, about the support that was provided by Air France to Air France KLM, and where the French state attached certain green conditions. Professor Hanschen, could you please share your thoughts with us?
Thank you very much. Thank you both Joris and Pim for kicking us off, and for the generous introduction from Joris, and for Pim for setting the scene so ably with his short introduction. So the temporary framework, as it's called, should expire because by its very nature it's temporary. And it will be very important, I think, to see what replaces this framework. As we know, it's already been amended several times, 5 already. But what we still don't really know is how the Commission will frame the exit strategies for a lot of the funds that have been permitted. And this could be really important, I think, for introducing some kind of conditionality. So if member states want to continue funding companies, you could say, well, what we have at the moment is more like rescue aid. But if they want to keep on funding, we'll go into presumably a stage which is more akin, similar to restructuring aid, just as we had when we had the financial crisis, and we had those 2 types of measures and those 2 stages. And it was really only with the restructuring stage that the Commission really started to impose stricter conditions. And as we know, the Commission was able to use those measures as part of that restructuring package to introduce a lot of new rules into the banking sector. at a time when there wasn't really that much harmonization. So it used the state aid rules to kickstart a great deal of harmonization in the banking sector. Now the question is, could it do that with COVID aid? Now, of course, it's difficult because COVID aid under the temporary framework extends to many sectors. You gave the example of the airline sector, but of course it covers everything. So it will be very difficult, I think, for the Commission to tailor detailed restructuring conditions for every sector that's covered by currently by COVID. It might well be that they can sharpen the rescue and restructuring guidelines, which will be reviewed eventually. That review has been postponed, but it is scheduled for, I think it's 2023 now. So that might be an occasion when the Commission could start to look again at the restructuring guidelines and, or at least the restructuring part of those guidelines, and think about introducing more sustainability-based criteria as to govern aid for companies coming out of the crisis. So that is not excluded, but it's a huge amount of work. At the moment, the Commission has been of the view that if member states want to attach additional conditions to grants provided under the temporary framework, that's really up to them. We've seen two main categories: sustainability type conditionality, but also tax avoidance conditionality has also been quite an issue. But it's really been up to the member states, and the Commissioner has said while she encourages member states to take those steps, she can't legally force them to do it. So it's essentially, it's their money, and as long as they comply with the conditions in the temporary framework, which are not particularly restrictive and are, as you mentioned, based on Article 1073B, then it's very difficult for the Commission to, as it were, smuggle in some extra conditions. And this, of course, has led to a lot of complaint from sectors where they feel that COVID aid is being used to preserve fossil fuel guzzlers, and it's a missed opportunity. But it's really up to the member states themselves. So you cited the French example, but of course the other partner, KLM, is not subject to those same types of restrictions, although they have announced that they will voluntarily commit to a greener future. But it's certainly not a condition. It's not a condition of the grants that they've been given. I think it's also important to draw another parallel with the financial sector. Looking back, many conditions were imposed in individual aid clearances under the financial crisis guidelines. And there has been an interesting report from the European Court of Auditors looking at the extent to which the Commission followed up on and enforced those conditions. And the Court of Auditors was not very positive in its assessment. They said the Commission had not followed up adequately. And I think this is an area of state aid control that deserves a lot more attention. We have, with many decisions, it's very rare for the Commission to adopt a negative decision and ban a state aid, even in the good times before COVID. But what tends to happen is that conditions are imposed in order for the Commission to grant a positive decision, and those conditions can be imposed even if the Commission does not open a formal investigation. So even in reaching a decision to close procedures after the 2-month investigation, the Commission can still adopt certain conditions. But it's usually within the context of the formal decision that you see the more far-reaching conditions being imposed, going back to the old days of airline restructuring, for example. You can see extensive provisions on privatization, and all sorts of conditions were used. So the Commission really did use state aid control to pursue very broad industrial policy goals. But the extent to which those conditions are systematically enforced is something that the Court of Auditors seems to have found wanting. Now, what's important also, of course, is that the trend in state aid control generally is towards more decentralization. So the Commission only picks the important cases, the tough cases. But as a quid pro quo, member states are expected to carry out ex post evaluations and to submit reports to the Commission on their findings. So has that aid been effective? Have the conditions that have been voluntarily proposed by the member states in designing schemes, for example, have they proved their worth? So the Commission is certainly getting a better picture, I think, of how state aid actually works on the ground and whether it does deliver its objectives. So again, looking further forward beyond the immediate confines of the temporary framework, I think there's a lot of scope to include a greater emphasis on sustainability going forward when we come out, hopefully, of the current crisis. So maybe there's some questions now on this topic. I don't know.
Does anyone from the audience have a question before we move on to the next topic? Doesn't seem to be a question. No questions. All right. I think it's fine to move on to the next topic, because I think we've quite a bit of territory to cover. And if you have if you only have questions on this particular topic later on, you can still ask them. We can still discuss them, I think. The second topic is a little bit broader and is about touches upon constitutional aspects of state aid and sustainability. And to be more precise, just last autumn, on the 22nd of September, the Court of Justice issued a judgment in the so-called Hinkley Point C case. And this judgment confirms an earlier judgment from 2018 by the General Court, which in turn upheld a Commission decision which allowed the UK government to provide long-term support to a nuclear energy plant in southern England. And the Court of Justice answered the central legal question whether the aid for nuclear energy plant could be deemed to be compatible with the internal market pursuant to Article 107, paragraph 3 under C. And there the Court of Justice stressed that pursuant to that article, it's not a requirement for the compatibility of state aid that an objective in the common interest is served. Nor is it necessary to always find a market failure. And the question is, of course, what does this mean for current Commission practice? Professor Henscher, could you please explain the possible impact of the Hinkley Point decision?
Thank you. Yes, I can. Well, I'll do my best because it's quite a complicated judgment. It's a judgment of the Grand Chamber, so it's a very important case. It's important for many, many reasons. It's kind of ironical that probably one of the most important rulings on state aid in 2020 concerned the UK, which of course at the beginning of 2020 had already departed and is now subject to its own regime, and that in the new TCA that has been concluded between the UK and the EU. So this case is it's important for many reasons, because strangely enough, although this Article 107.3 paragraph C for state aid aficionados, this is the basis, the legal basis on which about 90, well, at least before COVID, about 95% of cases are cleared on as compatible aid. So the Commission has a wide discretion under this article to declare aid to be compatible. But there's been hardly any case law on it, and everybody kind of forgets about that. Why not? Because normally it's actually very difficult to challenge a Commission decision. If you're a competitor and you're trying to challenge something, and the Commission finds against you. So the legal obstacles especially to challenging formal decisions after the closure of the final procedures, the formal procedures, very hard to get a case finally into court. So maybe that is one of the reasons why there has been so few cases where the court has been asked to look at the scope of this really crucial article. So ironically then, the UK delivered a possibility to do so. Why? Because, well, of course, the UK didn't challenge the Commission's decision. The UK was more than happy with the Commission's decision. The beneficiaries were happy, obviously, and competitors were denied standing as well, in a case brought by German electricity producers. They were not deemed to have individual concern. NGOs were also denied standing. Greenpeace had tried to bring an action. It too was denied standing. But Austria, of course, didn't have to pass the test of being a privileged applicant because member states don't have that high barrier to jump over. They can challenge whatever they wish. And of course, it's really unusual for one member state to challenge a positive decision that grants another member state aid. That's unheard of. I think this was the first time that this ever happened. Or the case, they couldn't get away with a standing type reason to kick it out. But the burden of proof that is imposed on Austria to prove that the measures were disproportionate, for example, is extremely high. And the court, in fact, says you have to show that it's manifestly inappropriate for the Commission to approve an aid scheme, which is, obviously manifestly inappropriate. It's a very high test for anyone to bear. And so I think that's quite an interesting side of it. So especially if you look at it from the point of view of sustainability, what would be manifestly inappropriate? That's really difficult, I think, to substantiate for someone opposing a grant of aid to let's say a fossil fuel plant, because is it manifestly inappropriate to allow a gas-fired plant to function for another 10 years while we're in a transition to something else? It might be manifestly inappropriate to allow a new coal-fired plant, but if a member state has no other possibility to generate electricity, is that manifestly inappropriate? So it's a very tough test. So that's a very important aspect of this ruling. But there are many aspects of this ruling that are extremely important. So one of the key findings of the Grand Chamber contrary to what the AG found and contrary to the General Court's findings, is that the Commission cannot approve an aid that is contrary to Article 11, so the environmental protection provisions in the treaty, contrary to Article 37 of the European Charter, and contrary to any secondary legislation pursuing environmental objectives. So what the court says is that when the Commission applies the first test of Article 107.3, paragraph C, aid to facilitate economic development, if it's contrary to European environmental law, stop. The Commission cannot approve that aid. So that is obviously a very clear signal from the court that sustainability goals, sustainability legislation has to be taken extremely seriously because it is in fact a red light. So no more messing around there. Whereas the Advocate General had taken a much more liberal approach and said if a member state is not adopting a measure in pursuit of the environmental objectives, then it shouldn't be judged according to the treaty rules. A similar approach taken by the General Court, but that has not been accepted. So that part of the judgment is very, very important. However, in this particular case, nuclear power is not contrary to European environmental law. On the contrary, it's promoted by the Euratom Treaty. So the court, the Grand Chamber found that the General Court, although it had ignored the importance of Article 11 and Article 37, this could not lead to the annulment of its decision because nuclear power is seen as a form of energy that is in the common interest because it's promoted by the Euratom Treaty, and the Euratom Treaty contains further no provisions on the environmental aspects of nuclear power. So that, in a sense, was a bit of a Pyrrhic victory then for Austria. It won the argument on the environmental provisions, but it didn't win the overall war when it came to using those provisions to stop a nuclear plant. So I think that was quite important. The other really important aspect going forward for sustainability and energy state aid is that the court put a lot of emphasis on what we call the energy mix provision. So in Article 194, paragraph 2 of the treaty, it's recognized that member states have the right to determine their own energy mix. And so the court seemed to say, well, this is a bit unclear, but it certainly seemed to say that the UK could then choose to have nuclear in its energy mix. But of course, and this would, be in its economic interests, etc. And it was not contrary to any environmental rule. So what the court then did was look at the proportionality of the measure, and in a way, because it took into account this right of a member state to adopt whatever fuel it wanted as part of its right to decide its own energy mix, the scales were already tilted, and it was almost impossible then to apply the second part of the test in Article 107.3, paragraph C. Did it have an adverse effect on competition and trade? No, it didn't, because it was already in the general interest of the UK, and it promoted its energy mix. And the court then went on to say, when you look at the negative conditions, the only conditions that can be assessed when you apply that part of the test are conditions relating to the impact on competition and trade. So any adverse impact on the environment cannot be taken into account in that second part of the test. So this seems to make it easier for member states to justify aid which is not necessarily pursuing sustainability objectives, but if they claim security of supply objectives, if they claim we need this, it's part of our energy mix, it's our right to decide upon it, then this ruling seems to suggest that they have a lot of discretion in framing their policy and giving state aid to realize that policy. Now, the other important, there are many aspects of Hinckley. We could talk about Hinckley all night, but I'm sure you don't want to. But the other thing is, what does it mean for the Commission's powers to draw up revised state aid guidelines? And we know the Commission is looking at a lot of the current guidelines. It's already carried out this sort of fit for purpose review, and it will go on next year to look at a more substantive review. It's in some cases already doing that, but across the board, across all the state aid guidelines, it will complete a more substantive revision. And as Pim said, the court said, well, you do not need these tests. You cannot require a member state to show that a measure is pursuing an objective of common interest, nor can you require it to establish that there's been a market failure. So these two conditions, these were common across all the state aid guidelines, because the state aid modernization exercise of 2013 had imposed a degree of consistency across all the state aid guidelines, and these common assessment criteria then feature in every guideline. So the big question is, well, can the Commission still use those sorts of criteria? Can the Commission say, well, in a guideline, we consider the following to be objectives of common interest, and therefore the Commission limits its discretion as to what it can declare compatible. But of course, it also limits the rights of member states to come up with other grounds of what might be common interests. And the court said they can't do that. So the treaty doesn't provide for that. If you look at the text of 107.3, paragraph C, those words you can't find. Where can you find them? You can find them in 107.3b. That's where that test is featured, but not anywhere else. As for market failures, the court said you don't have to, you can't require that member states only pursue projects where they can demonstrate a market failure. It helps, but it's not a necessary condition for aid approval. So one of the interesting consequences of Hinckley is, well, what will happen to guidelines, and to what extent can the Commission impose more positive criteria when it tries to balance out the pros and cons of different types of aid? So that's something that's very much debated at the moment. And when the Commission announced indeed that whole debate on sustainability and the competition rules, in the call for papers to be submitted in the consultation process, one of the questions was consider the impact of Hinckley, of this ruling. So the Commission was very much aware of the limitations that this ruling might impose on the way they use state aid guidance as a set of positive criteria. So it's an important case.
All right. Are there any questions from the audience? I understood that you had a question.
Yes, I have one question, maybe more a question of procedural kind. So according to Commission reports that we saw after the financial crisis, some claimed that the financial crisis had led to an increase in private enforcement of state aid. So if you want to be a bit edgy, you can say that the lack of public enforcement at that time has caused private enforcement to increase. Do you expect yourself purely intuitively that such a surge in private enforcement will be a consequence as well of the temporary framework?
Thank you. Yes, that's a good question. Yeah, private enforcement has it increased. Well, there's certainly, well, the Commission produced a report last year looking at private enforcement because one of the aims, the objectives of state aid modernization has been to increase decentralized enforcement and encourage private enforcement as well. So to encourage the parties to go to the national courts. And indeed, if you look at the numbers of cases that are brought, they are quite high in a number of member states. But if you look at the number of successful cases, and I mean successful in the, not necessarily in terms of whether or not the claimant has been able to defend and win its claims that something is state aid, but that it has standing and that there is even a state aid issue, they're rather small. Because the majority of cases that end up in national courts usually concern taxation. And that, of course, is very problematic because it's very difficult to use state aid rules to claim that you should get an exemption as well as somebody else to get standing in national courts. So that is problematic. And of course, member states are supposed to have procedural autonomy, so it's difficult for the Commission to come up with rules as to, when member states courts should grant standing or apply the definition of state aid in a particular way. We do see, of course, the Commission intervening more often, providing amicus curiae. There was a case in Italy where the Commission actually intervened in person and pleaded before the court. That case went then on to the Court of Justice, but I believe it's been withdrawn, unfortunately, because it would have been interesting to see how the Commission's views at national level were then transposed to the European level. But I think private enforcement is still rather difficult. There are many hurdles.
Okay, thank you.
Yeah, it's an interesting question to think about also in the context of private practice. All right, any more questions from the audience? If not, I suggest we move on to the next topic. Also a very interesting topic, the communication on important projects of common European interest. Now in 2014, the Commission first adopted a communication on important projects of common European interest. And in a bid to address important or systemic market failures and societal challenges that could not be otherwise addressed, this framework aims to encourage member states to support projects that make a contribution to the EU strategic objectives. And this has been a success to some extent. That the communication has been applied in a number of fields, such as infrastructure, for microelectronics, for the battery value chain, and for hydrogen. And Professor Henscher, I was wondering, to what extent would you recommend to also take into account sustainability in devising such rules for important projects of common European interest? Would that be feasible? And if so, what would it actually do?
Okay, thank you. Yeah, I think these are very important projects. And you've mentioned the two battery alliance projects that have been approved under these rules, and then the hydrogen alliance. they are seen as essential it's an essential tool for the Commission in realizing its Green Deal objectives, because let's not forget that research and development is really important for the Commission in the context of the Green Deal. Not only do they want to showcase industrial policy in this respect, European industrial policy, but as you said yourself, they want to make sure that we have the supply chains are being developed and all the necessary materials are being properly developed in Europe. So R&D is really important, and we've missed our R&D targets I think since the targets were set. This has always been a kind of an Achilles heel. So the Commission is always trying to push more R&D, and these projects, these big projects, are really important for, kickstarting across Europe important projects. Most of which, then the recent ones, the batteries and the hydrogen, are meant to definitely stimulate sustainability and to provide sustainable solutions for energy use. So they're extremely important. The IPCEI communication from 2014 has just been reviewed because it would expire last year, but it was prolonged. But the Commission made it a priority to review the substance of it. The consultation just closed 3 weeks ago, at the end of April, 21st of April. So we're not yet sure in what direction the revisions will go. But I think one of the stated revisions the Commission has said that it wants to adopt is to make these projects more accessible to small and medium-sized companies. Because they're very, you could say, very bureaucratic. There's a huge amount of rules that have to be complied with to participate in these projects. And what's very interesting, I think, is they encourage the setting up of a lot of joint ventures. There's a lot of, obviously, the whole purpose is to get companies to collaborate, communicate. These companies might be each other's competitors. So there's obviously a whole sensitive dimension to make sure that a project is not used for the purposes of cartel-like agreements. So they're very complex, I think, in terms of how you participate. There's a very extensive governance structure to prevent them being used as a way of promoting price or pricing agreements, cost sharing agreements. So they have to be quite heavily policed, if you like, as well. And unfortunately, we don't really know that much about how they function because it's not the most transparent of processes. The Commission's very keen on it. I think we'll get more of them. But it would be also good, really, I think, to know how they're working as well. Because I think that the final decisions have still not been published on the Battery Alliance cases yet. And they, some 2 years ago that those decisions were adopted. So, and the Hydrogen Alliance, I think, is equally, we know that the Commission reached decisions, but we don't know much about them beyond a press release, right? So it's a pity that we don't know how they're functioning either. But I think they're very important.
I maybe have one question. You rightfully say, I think, that this IPCEI communication is fundamental also in terms of the connection between industrial policy and state aid. But how would you explain that it is this rarely used as a legal basis? So we now have two projects that were notified under the communication. What do you think? What are the main aspects that make the threshold very high to use this as a legal basis?
Yeah, good question. Well, of course, we had, in the old days, we had some infrastructure projects, Pim also pointed out. So, you know, the Great Belt Bridge between Sweden and Denmark, for example, and there's several railway bridges, I think, also that have been between those countries that have fallen under this exception and have been declared to be these types of projects. The communication itself is from 2014, was kind of codifying practice. I think it's been difficult because you have to show not only that there are several countries involved, but that the benefits will be widely distributed. So it's not just, you know, concentrated in a couple of countries. So it's quite a, yeah, I think that's been part of it. It's an onerous process to actually get the exemption. And again, you know, it's given the Commission the opportunity to introduce all sorts of trade-offs as well. With infrastructure projects, for example, you know, lots of things about access, and which it might not have, you know, had the possibility otherwise. Microelectronics, I think there are a lot of conditions about sharing R&D results and patents and licenses. I can't comment on the battery alliance because we don't know what's going on in there, but it gives the Commission a lot of powers to really steer things, you know, and I think it's a very important industrial policy tool for the Commission, which means, on the other hand, that for a member state, suppose you're Germany and you think, oh, this is a great idea to promote batteries and I'll put a lot of money into it, but you're not in the driving seat, right, as a member state. You're just one of a number of passengers in the bus, and it's the Commission that's, you know, is ostensibly the one driving the bus. So for member states, that's maybe not always very attractive, because if you're really going to put a lot of money into big prestige projects, you probably want to really be controlling what's happening to a much greater extent. So that could be the reason. On the other hand, there's certain things that, you know, with hydrogen, I think people agree that a lot has to be done very quickly, and therefore there are a lot of benefits in cooperation. So I hope that answers your question.
Yes, certainly. Thank you.
Any other questions for this particular topic? If not, it's already 8 o'clock. I suggest we move on quickly. Still a bit of territory to cover. The fourth topic is basically the evolution of EU's foreign investment screening mechanism to the Commission's most recent proposal for a regulation on foreign subsidies. And as I briefly discussed in my introduction, the EU is increasingly adopting a more assertive stance with the objective of ensuring a level playing field and fair conditions of competition in the single market, and thereby realizing its open strategic autonomy. And it is in this perspective that the EU recently adopted a framework regulation for the screening of foreign direct investment, and that very recently, just not even a week ago, the European Commission adopted a proposal for a regulation on foreign subsidies distorting the internal market. Professor Henscher, maybe just to start with a very general question. What is your assessment of this new regulation on foreign subsidies? Do you think it will work? What sort of practical difficulties do you see in its actual application?
Thank you. Right. Well, first of all, of course, it still has to be adopted, right? We have the proposal. The Commission consulted and then came up with the proposal now. So we have to wait and see what will come out of the legislative process and what the Parliament and the Council will agree to. I think that the Commission seems to have a lot of sympathy, I think, political sympathy, that something has to be done. Certainly when it comes to mergers, I think that it, has obviously, because it already has the powers to prevent a merger, then adding on this additional screening makes sense, and it's not going to be terribly difficult, I think, for the Commission to use its powers. I mean, legally, to say, well, we're going to block this merger, or we're going to impose conditions because because the merger reaches the threshold in the proposal. So that, I think, is not unworkable. On the other strand, on procurement, where the Commission could try to block procurement because it doesn't, again, there's the threshold, or obviously that might change in the current, in the negotiations before the measure is finally adopted. That will be interesting because, of course, the Commission does not have formal powers to intervene in national procurement policies. There is, of course, the famous case where it did require Bulgaria to use the procurement rules to frustrate the South Stream pipeline because for geopolitical reasons that wasn't wanted. So there is a precedent to use procurement maybe in a way that people hadn't maybe predicted to stop a foreign investment project. And another interesting case, which is actually before the court, and is actually also about nuclear power, and is again a case brought by Austria, concerns the Hungarian plans to refresh its packs. This will be financed by Russian investment, because the technology will also be Russian. Now, when the Commission investigated that measure, that project, there were allegations that the procurement rules had not been properly applied, state aid issues, and of course, the question then arose: can we apply the EU state aid rules to this type of project when the financing isn't coming from a member state, it's coming from a third country? And if you read that decision, the Commission says, no, we can't. So the new provisions will be important because if the Commission gets the power under this proposed regulation to consider subsidies from third countries, then that will be an important new form of control that the Commission can use. Also, it will have this market investigation power. But the question is whether it will get the information. That's going to be really interesting. So, I mean, we see FDI powers being adopted at in every member state. So this is sort of part of a trend, which obviously goes beyond screening, because we do have that regulation now as well in place. But I think this is an important, I think it's obviously it serves the purpose of strategic autonomy and could be very important in the energy field, given that most of our energy will be imported, even when we go green, and even more when we go green, probably.
Yeah, it's quite interesting, because the way I read it, what this proposal does is in essence externalizing the EU state aid law framework to other countries, because and of course the difficulty is, will other countries accept it, and will there be ways to circumvent this? So, for example, in the context of public procurement, what happens, for example, if we've seen this in the Netherlands, where for example, a certain province is wants to acquire certain electric buses. A French company wins, but in turn acquires all the buses from China. And this is, for example, something that's not strictly covered, I would argue, by the proposed regulation. So, yeah, there is the issue of circumvention, which will be very difficult, and as well as you raise, to obtain all the information from, for example, from companies in China or in Russia, that will be very difficult.
Yeah.
And there might be a lot of geopolitical pressure here as well in play. Yeah.
And presumably there's nothing to stop, let's say for the sake of argument, in the case you just mentioned, the Chinese investor operating as a market investor, and it's not state aid.
Yeah.
Or would you apply a different standard just because it's a Chinese state-owned company, for example? Or
well, I think the idea is not to apply a different standard, but to apply the same standard as you would apply within the European Union.
So the return that the investor should get, is that the return that it would expect on the European market or in the Chinese market? That will be an interesting question.
Yeah. Whereas in China, different market conditions may apply, and different regulatory framework in terms of social protection and so on and so on and so forth. So that's what I find interesting in reading the regulation, also the white paper before that, is the introduction of a so-called EU interest test. Has that been now properly defined in the regulation? Because based on this EU interest test, action would be taken against foreign subsidies if they frustrate the achievement of EU policy objectives such as job creation, climate neutrality, and environmental protection, etc., etc. What do you think about this EU interest? Has it been sufficiently defined, or what do you think?
I don't think so. It sounds to me like it's very wide indeed. I suppose only precedent will tell.
Yeah.
But it's surely not in the interest of the Commission to try to define it at this point in time either.
We have a question from Mr. or Miss Stepanovic. I would be happy to read out your question, but maybe you want to raise it yourself. If so, please unmute and ask your question. Oh, no microphone. Okay. The question is, I would like to know, is any state aid for waste management for batteries recycling? Is any state aid? I have difficulties to read this question.
Maybe has there been a precedent, maybe, or a decision from the Commission?
Yes, there has been. There have been several decisions on this issue, because of course recycling is really important for batteries. So there have been, I believe, there have been German measures, and maybe also, I can't remember exactly, but there have been national measures aimed at better recycling, and they have been approved. Yeah.
All right. Okay.
I think there's also a big Polish project, if I remember now. I think this is one of the areas where the Polish government putting in a lot of investment to stimulate the battery industry and the recycling of batteries in Poland.
And Maurits just kindly included a recent example in the chat.
Okay, good.
For your
Thank
reference.
you.
All right. Any other questions or observations? If not, we'll move on to the last topic. For me, quite an exotic topic, but could be of incredible relevance to the topic under discussion. It's the taxonomy regulation. On the 22nd of June 2020, regulation 2020/852 on the establishment of a framework to facilitate sustainable investment came into being, the EU taxonomy regulation. And this regulation establishes the criteria for determining whether an economic activity qualifies as environmentally sustainable for the purposes of determining the degree to which an investment is environmentally sustainable. Professor, could you please discuss what possible implications this taxonomy regulation may have in the context of state aid in general and state aid and sustainability in particular?
Thank you. Right. So this is a really difficult question, which I think is really kind of raising a lot of novel issues. So the taxonomy regulation at first sight doesn't have much to do with state aid, but late April, I think it was 21st of April, the Commission passed a delegated or agreed to the text of a delegated act that further implements the taxonomy regulation. The taxonomy regulation empowers the Commission to adopt delegated acts to then further detail how the taxonomy will be applied in different areas. And the delegated regulation that was finalized a few weeks ago deals with climate. There'll be one on biodiversity, for example, one on land and agricultural use, but the climate one has been really controversial because, of course, everybody wants to be sustainable. And the whole idea behind the taxonomy regulation is just to prevent greenwashing, so that when banks or investment funds try to tempt investors to buy green bonds or invest in green funds, the public knows that, in fact, the investment really is into something green. And so these delegated acts then provide further criteria for what will be really considered to be green, to prevent then this greenwashing. So for the delegated act on climate, the big issue, or one big issue is nuclear sustainable or not? Because the idea is that gradually, if big pension funds and investment funds say we're going to get out of fossil fuels, we're going to get out of nuclear, then they will be made to honor their promises to their investors, and everything has to be very transparent. So the question then was, is nuclear sustainable or not? So that was tricky. The second, even more trickier subject is gas. And is gas then to be considered sustainable or not? So the Commission really postponed its decision on those two fuels. So the new instrument that has just been finalized doesn't yet cover gas and nuclear. And the Commission has agreed that a second instrument will be adopted, where the criteria as to the sustainability of these two fuels will be further detailed. Now, if you think about hydrogen, we were just talking about the IPCEI for hydrogen, huge amounts of money being committed at national level, backed by the Commission, to invest in hydrogen projects. And these projects, I mean, it's not just about public money. The whole Green Deal is meant to leverage, insofar as European money, that's meant to leverage a huge amount of private investment. And that private investment then has to be green. And that's where the taxonomy comes in. So the question then arises, and this is perhaps a bit of a roundabout way of explaining, state aid funds that are approved then, they're either European funds or where the Commission is approving national matching funds, which in turn are supposed to help leverage private investment, will have to, I'm sure, comply with the taxonomy criteria. And so this is now, I think people are just waking up to the implications of this, especially in the hydrogen sector, where we won't have green hydrogen in the foreseeable future. It's going to take quite a number of years to move from what we call blue, which is kind of mixed natural gas and hydrogen, to green, which is truly green in the production of hydrogen. Well, will this be sustainable or not? Will this qualify as green funding? So it's going to be really difficult, I think, when we see how that next delegated measure will be framed, to see how this is going to work out. And then go back to Hinckley, go back to what the court said, that the Commission cannot approve any state aid measure that's contrary to European environmental law. And these provisions are surely part of European environmental law. So that's why Hinckley is such an important case as well.
That is very exciting. We have got a question from Catherine Banet. Catherine, would you like to raise your question yourself?
Okay. Hello, good evening, everyone. Heidi, nice to see you.
Hi.
No, I was just wondering if, because that's part of the procedure of the delegated act, that the Council and the Parliament may actually object the adoption. Do you think there is a real risk of that? Yeah,
good question. I mean, obviously the Parliament was very, concerned about both the gas and the nuclear aspects. And the compromise, as I understand it, is then that the Commission, has said, okay, we'll just defer and we will come either with a new act or we'll revise this act in the very near future. And I believe what they have now said is that they will do that. I thought it was going to be next year, but in fact, they've said they will revise it already in the autumn. So I think that what they will try to do is then persuade the Council and particularly the Parliament that the stricter measure will be adopted just a bit later. But there's been an enormous amount of lobbying, of course, to prevent gas not being included in some form or other, and to get better guidance. Because I think, as I said, I think people are just realizing the consequences of what might happen. And so it will also mean we'll have this Fit for 55. Well, we have this ongoing Fit for 55 revision of all the environmental directives, RES 2 and energy efficiency, and all the criteria that will be adopted in that new legislation and in the new gas package will all obviously have to be tied into this taxonomy discussion as well. So it's, I think, opening up a complete can of worms that maybe, hadn't really been thought through when the whole initiative was launched. And I think this is where state aid law will also, meet some very new and interesting challenges.
All right. We've got a further question from Maurits Doelmans. Maurits, can I please give you the floor?
Well, fine. Thank you. Sorry to be late here, but one of the difficulties with the delegated act, it seems to me, and also with the Green Deal in general, is that it seems to be kind of frozen in the current time and doesn't. How much scope is there for further adjustments in response to new technologies being discovered or old technologies being rediscovered? For instance, I just heard about thorium reactors, molten salt reactors, which is an old technology which existed since the 60s and which actually can create green energy without, at very high temperatures, without any CO2 emissions and with very little, much less radiation than nuclear, in fact, almost none. And yet there's no reference to that kind of technology in the Green Deal. There's nothing in the taxonomy that would suggest that those kind of technologies could receive a green finance qualification so as to be more attractive financially. Is there still scope to amend things? I mean, there are other aspects too in the taxonomy. For instance, I read that hybrid electric vehicles are now subject to time limitations. Suddenly people have discovered that hybrid electrical vehicles, if there's not enough connection points for electrical charging, are being driven on gasoline, and because they're heavier, they actually emit more than greenhouse gas. So now they're putting hybrid vehicles subject to a limitation. Wouldn't the better answer be to invest in electrical grids, capillary, with sufficient capillary density, so that it becomes easier to charge these hybrid vehicles and electrical vehicles, so that people start to charge them more and people find it easier to move to fully electrical vehicles? So it seems to be that some counterproductive decisions are being made in these taxonomies, and if it's a take it or leave it decision at this stage, it sounds pretty dangerous to me.
Yeah, no, this is exactly the point I was trying to make. We haven't got standards aligned properly with this new taxonomy, and indeed everything that we adopt in the Fit for 55 process, all these new standards, then will have to be worked into this taxonomy. And indeed, you have the danger, will they be frozen, if you like, frozen in time, which probably means, but if you look at the instrument, the delegated act, if you look at other areas, maybe I'm not an expert, but if I think about REACH, there are ways, of course, of updating things. I mean, that's why we have delegated acts, because it's easier to update them and implementing measures idem dito. So what you might see to address the kind of concern that you have just expressed is that you'll have to constantly have these measures updated to reflect all this change. And then you'll get lots of discussions probably about the scope, whether the Commission's allowed to do the things it might want to do by amending delegated acts. We can think of the famous Dyson case on energy efficiency and vacuum cleaners, and that I think it took about 5 years to get those delegated acts.
Okay, let's go.
Oh, I hear somebody.
Ja, maar... Oh, ja, maar...
I think it's exactly the people are now making these connections and realizing that it could be quite counterproductive, especially because we're in a transition, and what will the impact be of all this legislation on the speed and efficiency of that transition. That's really going to be, I think, very important to consider.
If I may,
vintage salt generation, I'd never heard of that.
It's really worth looking into. It was new to me, and I heard a scientific explanation of it yesterday. I listened for 2 hours to a presentation on the science behind it, and it is remarkable. It's really remarkable, and it really deserves attention.
And where do we find it? I hope it's
well. I included a link there. I included the link in the question. So there are some. There's I can bore you now with thorium generation talk. I probably shouldn't. But the bottom line, it's really worth looking into it. It seems to me, from what I heard yesterday. But then the practical question to follow up on your comment on taxonomy, you said there's still the possibility. It's true, of course, as you say, that delegated acts, that the purpose of them is to allow quick amendment. Have you heard any willingness from the Commission to consider amendments, or Is there any plan to amend them regularly to update?
That I don't dare say. I did hear an old colleague mention that was certainly on the table because of just these concerns that, you know, that the industry is starting, I think, seriously lobbying the Commission to try to make sure that they are regularly updated. But, and also because there are so many open questions. You know, can you, if you want to build a catalyzer to facilitate blue hydrogen production, you know, you're going to have to commit a lot of investment. And will that be recognized in the taxonomy? Will it be in? How long will it be in for? What happens when it gets maybe taken out because we should be moving faster from blue to green? You know, it creates all these uncertainties. So on the one hand, yeah, you might want to have the lists amended frequently. I mean, they do that with REACH, they do that with many chemicals, so they should be able to do it. But I mean, if you look at the litigation under REACH, it's pretty extensive. And not to mention, of course, the courts have said you'll only get one bite at the cherry with REACH litigation. As you probably know, you can only appeal to the General Court. You don't go further than that because there are too many cases. So they've stopped it at the level of the General Court. So this whole area, I think the whole area of delegated legislation is another super interesting area. To get, you know, the institutional side of the Green Deal, I think we haven't really started appreciating in full yet. But it's a great question. Thank you.
Thank you.
Any other questions from the audience? No? All right. Well, I'm afraid we've almost used up all 90 minutes that we had. Professor Henscher, thank you very much for sharing with us your thoughts on state aid and industrial policy in the context of sustainability issues. Joris, once again, big thanks to you for organizing this event. And also thank you to KU Leuven's Centre for Global Governance Studies and the research unit Economic Law for the hosting of this event. All right, Joris, I'll give the floor to you maybe for some last comments.
Yes, thank you, Pim. Just if you have any questions left after considering this interesting debate, because it was maybe a lot to take in 90 minutes, don't hesitate reaching out. You can always send me an email and I'll pass on the message to either Lee Henscher, either Pim Jansen. Thank you very much, Pim, Lee, for this incredible debate. Hope to see you soon. And thank you everyone who intervened. I thought it was very interesting. Thank you very much.
Thank you. Thank you for hosting us. And I hope everyone has a good holiday tomorrow. I think in many places it will be a holiday. So.
Yes, indeed. Okay. Thank you. Bye-bye. Nice evening.
Bye. Thank you.